Minor got to hear it. But Minor got to hear it. Great.
Minor got to maybe he's typing.
It was very edifying, I have to say.
Hey, Minor, you haven't heard about my running career.
I'll leave that up to you, Jane. Go ahead.
That's in the 5:31 time slot. She's going to be talking about that. Right. Okay, I would love to bring our special Sunday 7-11 meeting to order, and just say that the goal for the next hour or so, we're scheduled for an hour and a half, but what we would like to do is give the committee a chance to revisit language of our amendments and subsections, and with in mind having something a little bit more together and refined and questions answered, so that we avoid a replay of our last meeting where there were still questions and space between where we were and where we would like to be. So this was scheduled to be able to try and close that gap, get some input from the prosecuting attorney, and to try and sort some of these questions out, and kind of collapse in on what our real goal is here. So Randy, you should have a list of questions you had asked us last time we were all together, for questions that this group had kind of around the topic. And I think a number of those really stem from your comments from July 7 on and before also, but on the submission of the amendments as written. So we don't really have a format today other than to make sure everyone's questions get answered, and make sure that we all feel good about the language goals in these amendments, so that we can finalize these as soon as possible and have them to present to County Council this week. So Jane, I don't have a handy list of those questions. If they're needed, we can post them. But Randy, was that sufficient time to be able to research or to respond to those? Are you willing to kind of? Okay.
Yeah, I'm happy to.
So my idea, I think for now, go ahead.
I'm happy to address the questions as they've been posed to me. They may not be the end of the discussion, but it'll kick us off. And maybe it's best to just take them one at a time. And then have a discussion about it. And then I'm not suggesting that you reach agreement then, but when the discussion ends, then let's move on to the next one, so that we have the full view of them, and start with the questions with non-discrimination clause.
Okay.
There's two parts. There's part one, which is the non-discrimination clause, and then there's part two, which is the contractual reference to the non-discrimination clause and inclusion language. So I was just checking, I was looking at the language that
while you look, Randy, I'm just a head nod. Sharon, are you taking notes again today? Are you able to do that? Great.
Yes.
Thank you very much. Perfect.
And Randy, do you want to do a screen share of the revised version that of number one, clause one, for amendment number one? Do we need to screen share that or not?
If you can do that, that's easier than me.
Yeah, no. And so Kyle, you good with that? If I go ahead and screen share that?
Yeah, you should be able to do it right now.
Okay, all right.
If not, I can find it, and it'll take us.
Yeah, let me give it a shot. You guys know how good I am at this, right? Okay. Every time I try and find one, too many documents opened. So again, I request your patience.
Let me know if you'd like me to find it.
Yeah, okay, I will do.
Have it open.
You do have it open? Do you want to screen share it, Sharon?
Which one do you want? Non-discrimination?
Yeah, the one, yeah. I'm not seeing it right now. let's have a race and see who gets there first. Oops, did I get the, okay, you got there first. Excellent. Okay,
Is that the right one?
you got it.
Okay.
I believe so. We want to scroll down just a little bit more. I believe that's the right one. Yeah, you got it. So, Mr. Chair, do you want me just to introduce it so Randy's clear on where we are from where we were?
Only if it's needed. I think.
Yeah. Okay.
Just if we could jump to questions.
Yeah. Yeah.
That were posed and see if that generates the kind of conversation that helps us.
Yeah, and let's see if Randy has questions for us. Yeah.
My recommendation, okay, so the first question concerns what do I think about the language in subsection 1, I think. As you may recall, what I had recommended was that you look at the language used in Snohomish County, and Commissioner Jane Fuller had started making changes, taking into account that language. And the language was intended from Snohomish County was seen as preferable because there was no question in my mind that it was intended to apply to county, the people who work in the county. And it was not intended as what we call a police power regulation. That means a rule that applies generally within the community to all businesses and all people. Okay, so the wording change was made to accomplish that, and that's good. And so you have that language in the exercise of its powers and the performance of its duties. The county shall ensure, and so on. So that's all good. There's one difference between Snohomish County and this is that the Snohomish County uses a reference to and incorporates state and federal classifications for non-discrimination identity by reference to them generally by reference to state and federal classifications. Whereas this goes through and makes a list that's somewhat broader than the state and federal classifications. It seems to have all of the state and federal classifications, and it has a few other things. And my comments to Jane about that were that I thought that you were pretty firm and fixed on adding these other classifications so that, to just focus only on state and federal, which would be my preference, was not going to get there. But in any event, as long as it stays local and is the obligation of the county, it's something that's manageable, I think. That said, there are others who have other county, I think it was James Wolf and HR said this is an invitation for additional lawsuits on the new classifications. And my comments to you are that that probably is true and that there is very little guidance from courts to see us through that. And that means those lawsuits are not going to be easily resolved. So for example, where you add body type as a classification, that is something that is not under state or federal law. And where you add age except by minimum age, that's not under state or federal law. Where you have retirement provisions, that's not under state or federal law. And so you can make it a list in comparison. And because you've enlarged the list of classifications, that's a potential for lawsuits and things that are expressing new areas. And so that's that. The other thing that the Snohomish County language does that is not done here is that it incorporates the case law that and standards that allows, it says, or any other basis not reasonably related to the accomplishment of a legitimate government purpose. So that there's this requirement that the county show, if it is going to discriminate, that it has a legitimate purpose in doing so. You know, I'm not going to try to estimate what those are right now, but there are sometimes legitimate government purposes in discrimination or in hiring intentions. I think the health department right now is hiring somebody, for example, to provide aid with breastfeeding of new mothers. And they want a person who's had experience with breastfeeding as a mother. And so there will be gender discrimination in connection with the hiring of that position. And that's seen as a legitimate government purpose and a accomplishment of a legitimate government purpose. And so that exception would be applicable under the way you've drafted this with no exception. It would be not applicable. We could put that requirement in. And so there is sometimes a need for some flexibility, and that's the purpose of that language in the Snohomish County provision that makes sense to me, and I would urge you to accept it. So that's what I have with respect to clause 1.
Mr. Chair?
Please, Kevin, go ahead.
Randy, a question on that last piece. So particularly the example you just gave obviously makes sense and is a rational reason for why you'd have an exception. Is there a way to write that so that you can guarantee those sorts of exceptions aren't abused? Is there a way to, I mean, maybe they've done it. Maybe the Snohomish language is that, but I just, you know, for me, every time I see an exception, I try and do the red teaming where you're considering, you know, what's the way it could be misused.
You know, if we had a problem that we were dealing with, then I could address that more plainly. I think for purposes of a charter and the general purposes of a charter, this is not a bad. It's in the Snohomish County Charter. They've vetted that through. I think it's worthy language, and I wouldn't. I think it's good. I think it's good.
Mm-hmm. So Randy, Mr. Chair, can I ask Randy a question on
yes,
this?
please. Let's have this be open as long as we're not stepping on each other. Sure.
Thank you. Kevin, was your question answered, or because I had a related one, but
yeah, I think so. I mean, what Randy's, correct me if I'm wrong, Randy, but what I think you said is the Snohomish County language seems to be a good example of how that could be used, and the fact that they're using it. And I know Dave really well, and I've talked to him about this since reading your original memo. And I don't believe there's been any, you know, abuses or anything there. I just, you know, it's just one of those issues where you want to be as strong as possible and still allow it to be real, you know?
Yeah.
So.
Yeah, you need some practical side to it. And I think that does it in the language up there.
So, okay, so Randy, correct me if I'm wrong, but what I understand you to be saying then is if we took that text from the Snohomish County Charter and I've just pulled it up here so I can be looking at it. You're basically saying that if we adopted that specific language where it says, or on any other basis not reasonably related to the accomplishment of a legitimate governmental purpose, if we incorporated that, that would put us in better stead. Is that what you're saying?
That's right.
Okay.
And I think I would put it, let's see, trying to think of the location.
Yeah.
I think I'd put it after the word expression.
Okay.
And before the second sentence.
Okay.
Yeah.
Right. Okay.
I have a question while we're writing the editorial part of it. I'm not clear on who gets to use that clause. Is this in its powers and in the performance of its duties? Is that sort of generalized that, so in the health department circumstance, a department head and or a team leader then makes the decision to create this one-off or as needed government exception, and then does that on each case, does that come through your office, or how is that managed in part to answer Kevin's question? Who has the say there to determine whether it's legitimate based on the language or not?
Question. I would say that the most department heads would go to the HR director because he's the first line in the hiring process, conditions, compensation, termination. We all work with the HR director. We are really fortunate to have a very excellent HR director right now who is able and willing to deal with these things. And has been trained and has conducted training for others. So this would be when exceptions come along, people don't just charge ahead. They say, geez, this is going to be kind of different. We should check with somebody else. The first person they check with was the HR director. If he had any questions, he'd check with somebody in my office.
Okay.
And if we didn't have the talent at the moment, then we would contact an outside law firm or something to that effect. But we would have the talent in our office to deal with this kind of question right now.
Okay. I just want to say that to you and for the record both that this is really, I appreciate that it's enormously time consuming to consider for the whole CRC and our body of work over months and months, but it's not anyone's fault, particularly not yours, but this activity and this back and forth is really helpful to me. And I think really welcome. So thank you again. And, just being able to understand perspective and, try something on in the work of the committee with your support is really great. So
yeah.
Okay. Any other questions then or concerns about the addition of? As we go along, I'm okay kind of saving up these proposed changes and then making some decisions later.
Yeah.
We could also decide, sort of placehold.
Kyle?
Go ahead. Jane, did you have something?
Sorry, yeah, my internet's a little unstable right now. I just one other question. All okay?
Yes.
We can hear you, but you're frozen.
There you are.
Okay. Okay. I hope I'm back. All right. So, Randy, the other part of that first question under non-discrimination related to the modification of the sentence, the title. Sharon, if you could scroll up so we could see the title of the resolution, because what you had done was made it specific to county employment. And so a modification that I made on July 7th while we were sort of in that meeting was to refer it to in the exercise of county powers and performance of its duties. That's what the subject of non-discrimination pertains to. Is that acceptable? I'm wondering for this.
Yes, very good. Thank you, Jane. And that's great. The language you have is a good substitute and more complete than the language that I had. This is what I call the short title. It is not the title that goes on to the ballot. There will be more words on the title on the ballot, and it's really so that you know what this proposition is about. And it's intended to just be a few words in the most general way.
Oh, I see.
Sometimes and I'm going to ask that the auditor include this or some they may just say concerning the subject of non-discrimination because they can't put all of those
Right.
other words.
Right,
Yeah.
right.
They just have just a few words that they have space for at the
Uh-huh.
top of the ballot. And
Okay.
that's helpful to voters when they view multiple items that are propositions from the same group, for example, like it
Yes.
will be with you. And so I would say just concerning the subject of non-discrimination, that's good enough.
Okay, okay.
And but don't worry, that's
Yeah.
my task after you send these to the
Yeah,
county council. The auditor will ask me to put together ballot titles,
gotcha.
and
Yeah.
you'll see them. But I haven't even begun doing that yet.
Yeah,
And
yeah.
that's another step.
Right, right.
So you
Okay.
could just put it as non-discrimination, or you can leave it as you wish. What actually gets put on the ballot will be, I'm uncertain about at this point.
Yeah, gotcha. Okay, thank you. I just wanted to finalize that first sort of question
Yeah,
for,
good.
okay, excellent.
Good catch on that.
Thank you. Okay. All right.
Okay, are there any other questions in the list that refer directly to part 1?
Yes, it's the next question below,
Okay.
which is regarding the
Oh,
rather
you're
lengthy
Axelrod.
discussion. Yes,
Yeah.
and then, yeah, and it was also, you might recall, Randy, I think it was, you might not have been at that meeting, it might have been Amy, who was on the June 30th meeting. And David Dellendorf actually had made a suggestion prior to the June 30th meeting that we entertain the inclusion of sort of criminal conviction as one of the sort of identity factors that should be not subject to discrimination by the county. The fact that you have been, convicted or detained or what have you. So again, here I think an important point of clarification is that that is an identity factor that would obviously be problematic for the issue of employment of a county employee or official. We were not aiming at that. We were aiming more at in the treatment of residents or visitors to the county, in particular residents. That's really where we were, that was what we were thinking about when we were talking about including that. So can you speak to that? If, whether we can accommodate something like that?
My advice to you is to rely upon state law on this issue of criminal convictions. The state law is robust on that area and it's inclusive. I would be concerned about preemption if we tried to do something different than state law. So it's already something that we have to do. And the state law is very specific about the use of the criminal convictions information during the hiring process.
Right.
And state law says that you are to go through a two-step process. One is to identify people who are qualified for the job and then check their criminal history information.
That was the ban the box bill.
Excuse me?
That was the ban the box bill. It was my last year in the Senate. I was a sponsor of that.
Oh, ban the box. Ban what box?
On applications, historically, there's a box that you're supposed to check if you've been convicted of a felony.
All
And
right.
the bill was called the ban the box bill because it said, get rid of that box. No longer
I
ask the question.
So let me just be practical about this from my office standpoint. I check the criminal history of every person who applies to, or every person who makes it through the first step in the process in my office. I have to. I'm required to by law with respect to victim advocates. And it's absolutely essential due to the nature of the work that we do. And it's also, I believe, required as part of people who deal with criminal history rep sheets. And there are very strict provisions everybody's trained on with respect to keeping that information solely limited to the process of criminal cases and not using it for any other purpose. Okay. And so, but by the same token, federal law requires me to check people, and good practice requires to make sure that I hire lawyers and staff who are free from criminal convictions. Or if they have a criminal conviction, it's something that I can accept and live with, and I expect them to give me full disclosure at the outset. The same thing covers with police officers, and I would expect the courts have some of the same rules too. Some of the same rules will be checked with respect to those people who handle large sums of money. That's just required. That said, those are just a subset of employment situations in the county. And the county hires a lot of different people where criminal history would not be important, particularly criminal history that's misdemeanor types and so on. That said, I think that you can safely rely upon federal law and not include that here within your subsection 1. And I would urge you to just rely upon state law. There's a compromise that's made there. That's the place for it to be made, and it does apply to county employment.
But if
Randy, oh, go ahead.
Yeah, oh, sorry.
No,
Yeah,
go ahead, Jane, if you have a follow-up. I was going to follow your question.
Okay, yeah. So, because what I'm getting at, actually, really is that clause where it talks about in the first sentence, or in the treatment of residents and visitors, and you know how the county conducts its business and its treatment of residents and visitors, and whether that they could be subject to some form of discrimination as residents, for example, trying to get access to government services or what have you, because they, somehow it's determined that they've been convicted of a crime or something.
I can't think of a problem where that's ever occurred. I can say that people are jailed because of their criminal history frequently, because state law requires that. If it's your second conviction of domestic violence, you go straight to jail, or your second arrest. You don't. If it's your second DUI, you go straight to jail. You don't get to show up the next day.
Right.
There are things like that. So criminal history absolutely is part of keeping safe and safety in the community. And so when there's police contact with people, knowing someone's criminal history is essential. And so they examine that and often get it promptly before they leave the scene. So it's one of these things that are absolutely essential. And so that's why it's limited to, under state law, it's limited to the employment context.
I see to follow up, James, I see where there's value in, some of that allowance in federal and state law for law enforcement, but that's exactly where I think the rub is also. So there's a line between being able to, in my mind at least, being able to follow up on duplicate or follow-on crime and how a person is treated or handled, versus profiling or using a person's past proactively is the wrong word, but using that to profile or using that to somehow deny service, which I think is even, and I don't have a specific example to give you today, but I think that's part of the risk in a small community. That's even potentially more stigmatizing. So, I think that's really what we're after. And I don't know anywhere else that's dealt with it. I think it's delicate for that reason, but no less important to bring up and to try and try and protect that. It's another status that if you've done your time, or if you've paid in the eyes of the community, you've paid for that wrong, then and I appreciate that it's not super black and white, but there is a space where that element can be discriminated. It can be used to discriminate with, I think. So I think that's what we were looking for, is a way to protect or a way to extend that as a population that could use appropriate protection. Is that kind of what you're after, Jane? Or
Well, yeah, and actually, so and what I'm also thinking is that with the inclusion of that supplementary text that Randy's recommending that we incorporate from the Snohomish County Charter, I think that would cover the actions that the county may need to take for official purposes, reasonable official purposes, to exercise, some positive discrimination against someone on the basis, they get a second DUI, or they have a second conviction and being thrown in jail for a second domestic assault or something like that. I actually, so maybe Randy, this could help you sort of see it from a different angle. I mean, my brother was convicted of, my brother who's Black and adopted, was convicted of a crime in Canada and served his time in jail, and now he's he served his parole, and he's an upstanding citizen and all the rest of it. I could very easily see the possibility of my brother experiencing discrimination on the basis that his arrest was quite high profile. He's a very well-known musician in Vancouver, and so I could see some discrimination happening towards him on the basis of the public knowledge of what he did, and yet he's certainly redeemed himself as a citizen, served his time and all the rest of it, and so that's what we're talking about. We're talking about anyway. So Kevin says maybe not. That's what I was talking about.
No, I agree with you that has been part of the discussion, but for me, it also goes into the hiring. And I'll kind of counterpoint my point by saying I'm actually aware of an individual who was hired by the county who had a very high profile, visible felony, and they went to jail, they served their time, and they came back and they got a job with the county. And I see that person regularly doing their job, and they're fantastic and a great member of the community. And they made a stupid judgment a while back, right? So there's the kind of counterpoint. My other thing though is, and Randy, you brought this up, but I just want to be clear. And if you don't mind, I'd like to use your office as the example, just because you brought it up, and not to spotlight you, but is it the choice of the director, and in this case, you're the prosecutor, but you're also the director of your department, you're the head of your department. Is it the choice of the head of the department who vets it? They get to decide whether or not, if the person disclosed it, they could still work for you? Or is it that if somebody has been convicted of a felony, they're just not going to be able to work in certain areas? Is there flexibility there, is what I'm getting at?
Depends what the charge is.
Mm-hmm.
Context is everything.
Yeah.
You hear me say that all the time. Let me give you two examples. I had an employee who was an intern who told me that she was caught taking a political sign off of a median in Snohomish County, because it was the same, the candidate's name was the same as a friend of hers, and she wanted to give the sign to her friend. And a policeman happened to see her do that. She was stopped. She was charged with theft. And later she went to law school and came to apply to me to be an intern one summer. And she took care of it through a quick guilty plea, and just figured she'd deal with it all the way through law school. And she eventually became a lawyer, and I hired her for a summer, just considering a minor offense. That's the only person I can think of that I've hired that just had a criminal conviction. So it's something I was able to deal with. She disclosed it in our first interview. I can tell you also that truck drivers for the county and public works office workers have been found with controlled substances in their system, and they have been let go the next day. Also a crime. Okay. And that's because, no, we cannot have any of our trucks being driven by people with controlled substances. Even though controlled substances today is a misdemeanor, possession of controlled substances. So, you know, there's it's a huge area.
Yeah.
And it's difficult to say that there's a problem right now in San Juan County that I'm not aware of a problem that you're trying to address with this language. And that's why I just urge you to just stick with the state law and not try to build this into the charter.
Okay.
Hmm.
Okay.
I just, for me, and this is more of our discussion, I still, well, actually, I think the opposite is true, Randy. The examples I see in our community are that the county has actually hired people who have a mixed background and really given them a second chance. So I'd say it's actually the opposite of the problem, right? That said, that still does not negate for me the rationale or the reasoning for us trying to be bold and push an agenda that makes sure that people do get a second chance and that redemption is part of our, you know, part of our society, part of our community. And so if there's something that we can put in the charter that gets there, I want to do it. I also understand, and just like the previous conversation, excuse me, this needs to be realistic. But I would ask you, is there a way to go? And I recognize your strong advice to us is, you know, that we don't need to go there. The state's strong enough. Is there a way, can you think of any example of how we could craft language that could touch upon this or raise this subject in a way that helps San Juan County be out in front even further?
You know, this is a very tender issue. As you say, and I can think of somebody who went through drug court and was later hired on by the county and given a second chance and still works for the county.
Yeah.
And I've seen
The
these
one
people.
I'm thinking of had a federal felony conviction, you know, and
I'm not aware of that.
yeah.
And so, yeah, see, I'm not even aware of everybody's criminal status, right? It's not for me to know necessarily. I just am concerned about people who come within the four corners of my office. But I do have to take responsibility, and so does the sheriff, for access to the sensitive data that we have and information that we have, and that's absolutely essential. But you know, I think that the state law, I'm just going to stand on that the state law is the way to go. And I don't see why you would add something here in our local charter concerning that, unless you decide to do it as a separate amendment to the charter somehow.
Why is so? I don't want to get caught up in this. You've almost got me convinced on state law is good enough. Particularly, like I said, since I was part of creating one of those state laws that is on this agenda. But why would a separate amendment make it?
You know, I'm trying to help you here with the acceptability. As soon as you start adding things, you're going to find opponents to your measure. And the more new things you add, the more opponents you're going to bring. And criminal history is something that can be easily exploited as something that will present problems for county workers or county citizens. If they know that the criminal history isn't going to matter and who gets hired in the auditor's office. Well,
Okay.
it ought to matter.
I think what I hear you saying then is it's not that having it in a separate amendment would make it easier to draft or something. It's that it would have less risk of bringing down the other subjects we're talking about.
Exactly.
Okay, thank you.
Valid.
Okay.
Now I'm going to stop everyone for just a second and recognize Minor's comment. He has to leave, but appreciated the time spent, and
Maybe
thanks for the informative discussion. Thank you, Minor. Okay.
Mr. Chair, would it be appropriate to ask if he has any questions if we wanted to have a public?
It's not inappropriate. Minor, if you're still there, did you want to make any comment? I think he's dropped off.
Okay.
I don't see him. Okay, so for my benefit, then the total question number, we're at 4:45. Just for we'll just say that we're about halfway through our time. So let's jump right into it. Does that finish off then questions around number 1?
I would say yes, from my perspective.
Either posted or ones that have come up. Okay, so let's jump in. Randy, what do you have for question 3 that you have a response for?
Question 3. You mean subpart 2?
Yes.
Yeah.
All right. Subpart 2 looks quite similar to the original language that I looked at last
week. It is.
And,
just to be clear. Yeah, we didn't change it, but sorry, Randy, did interrupt you for a sec. So we didn't change it, but we did have an update to give you based on some work that Kyle did. But we did want to just pose this question that you see here, which is what language can be used in this clause that will enable the county to go as far as it is legally able to go in ensuring contracted entities adhered, blah, blah, blah. So yeah, that we kind of wanted to have a chance to talk to you about this. Yeah, in this setting.
Yeah. So you understand my advice on this. And my advice is that I found a case that mentions that this kind of provision was not proper in a charter in another state where it had been tested because it was viewed as being a provision that is not local. And you may recall from our first presentation, the case law is that charter provisions must be strictly local. And the concern is that you are attempting to alter the policies, the non-discrimination policies of businesses whose minor businesses working with San Juan County and who have broader other things or places where they work. And we can talk about multinationals as big as Microsoft as an example, to think that we cannot purchase a Microsoft product unless we get affirmation that they will adhere to our non-discrimination policy. If we request that, they will send it up to their lawyers. Their lawyers will look at that non-discrimination policy and they'll either give a thumbs up or thumbs down. And to the extent that it differs from state and federal law, they will observe that, notice it. And I predict that any alteration from state law will receive a thumbs down because they need to operate on a uniform fashion in all the locations where they work. And so we don't have a lot of room in negotiating those kind of things. The second area that we're concerned about is not only the big corporations, and that would be quite upsetting to our county. For example, I maintain a database system of and a document generation system that's where documents are held in the cloud on Google servers through a company based in Missouri that does business in about 50 different states. And if they said no, then I would have to either discontinue that and move to a paper-based system and just lose this efficiency that we have in our office. If we did that, we would hire more people to accommodate that because of the efficiencies of the systems that we have. It would be a big imposition, a big cost to the county. So there's some but financially unsound concerns with this language.
So Randy, when you brought that up, and I appreciate that, that helps me understand better. When you brought that up before with the wider group, I wasn't understanding. I didn't understand what you had written and your follow-up. I do now, and I want to paraphrase, make sure I'm right. So let's assume that the county with this clause goes after some particular product, either fleet cars or computer software or you name it. In order for us to accept any contract or bidding from them, they would have to have a non-discrimination policy that looked like ours. So at the very least, they'd have to adopt, nobody has two separate non-discrimination policies that they can throw around or, fit a key into a lock for a small county. So the problem is they would have to modify in your mind, and I want to make sure I'm right on this, they would be modifying their personnel policies to fit this, and thereby changing how they do business elsewhere also, or having to make an argument that they can legally and rationally carry two separate personnel policies. And I wasn't, is that kind of is that what you're saying?
Yes.
That's the extension. Okay.
And Kyle? Oh, I think Kyle's
Go ahead,
good.
Kevin.
Okay. So a couple things on this. One is, and I guess I'll counterpoint myself on this. So for me, I fully understand the argument Randy's getting at. And when I get to my counterpoint, I'll share some of the research I got from the chief counsel from one of our largest tech companies in Washington State, who's global. But I fully appreciate and understand the argument. However, and Randy, you're familiar with this, but that's the argument everybody told us when we went after jet skis. That was the argument people told us when we were doing guest houses, that we couldn't settle guest houses. But jet skis is a much better example. And we have a history in our county of being the mouse who roars and being bold and really pushing the agenda. And on this subject, I want us to be bold and say, no, we're not going to contract with anybody who doesn't do this. Now, the counterpoint. So a friend of mine is chief counsel at one of our firms, one of our larger tech companies. We'll leave it at that. And when I spoke to him, he basically said, look, it doesn't matter if it's state, federal, or local jurisdiction with a law like this. It matters how big you are. And he said, if this were Los Angeles County or the city of Manhattan, we would engage in a conversation. He said, with the county of San Juan, we can dismiss you. And then he went on to say, however, and this is what I had hoped I'd hear in the beginning, he said, however, we have updated 3 times in the last 24 months our basically our JEDI rules and so on. And he said, and I think right now we're stricter than what you're proposing. And he said, and most companies are doing that. And he said, but, and I shared with him, Randy, the comments that you had made, basically what you just said. And he said, that's entirely accurate. And he said, now maybe we're not the norm because we're trying to be more progressive on this, but there are, and the example he brought up, which Kyle, you touched upon, he said, look, in your fleet management, he said, General Motors may not have this, and not being able to buy, or Ford may not, have, and he was just making up, right? But may not have as progressive. And it would be a bummer if all of a sudden you weren't able to get any trucks for public works. So the counterpoint there is, I want us to push this envelope. However, I also recognize that with goods that we are purchasing, and I do see a separation, Kyle, which you pointed out to me this morning when we spoke, this could be a problem. And I don't like that. I want us to just say, okay, fine, it's going to be a problem, but that's also not realistic. It's not realistic for us to say, we can't use Intel, Microsoft, or Qualcomm, right? Okay, well then you're not going to have a computer. So I was very strongly in the position of, damn it, we're going to push this envelope. And I still feel we can, but I think that the point that Randy's making is actually one that for it to be realistic, that we need to consider.
Anybody else have comments? I was gonna add to that, but Jane, Sharon, anything you want to add first?
No, I defer to you, Kyle, because you had,
Okay.
you after the meeting on Wednesday, you followed up with a couple of conversations, so.
I did, and they're not, and it was really almost entirely your suggestion, Randy. I was able to talk to John Kane and to the county manager also, and both good conversations. I appreciated after that kind of 3 areas. One, our contract for services or professional services in that capacity, our contracting and needs for goods, some of them already mentioned, and then the very, very separate, which we haven't brought up yet, the very, very cautionary area of government entities or public entities where, we're talking about external contract offers that the county wants to take advantage of, like federal dollars for the health department, and on and on and on. And so that was the outcome of those conversations. And there is, I think there's room there to treat each of those to stay fairly, or to even maintain exactly how one reads and the reference to one insofar as professional services, where the county has to say and can be bold and can be prescriptive, not so much with the goods, and not at all really with the public entities, or the entities not listed as person, firm, organization, corporation, or non-governmental. I'm curious, posed that way, I'm curious what your thoughts are. I'm really reluctant to get rid of number 2 altogether. I do want us to push in that direction, but do you see it in a similar way? Would you counsel against separating? First of all, do you follow what we were just talking about?
Kyle, I hear you saying things similar to what Kevin had said, is where can we go that makes sense? And is it possible to make a distinction between types of contracts? Is it possible to make a distinction between types of organizations who we are contracting with, and so on? Those are good questions. I don't have an answer for you on all of those right now.
Okay, that's fair.
So that, because I had recognized that there had been some thought put into this in Snohomish County, and I can't say that I've done a comprehensive county survey in order to answer this question. The Snohomish County information was offered to me, and so I shared it with you, and it explains that they moved and had something in their charter, which I showed you, and then they had something else in their county code, which is more adaptable to the circumstances that come up, and make some exceptions. So it kind of adopts a rule similar to this, but again, they only rely upon state and federal contracting rules, and then they provide for some exceptions as well. So the long and short of it is that it's a process to arrive at something like subsection 2, and it's extraordinarily difficult to deal with in the context of the work of the Charter Review Commission. And that's why I suggested something through the county council, who would adopt an ordinance. There would be publication in advance. There would be notice and opportunity to be heard by all the people who might be affected by this, and things get modified. The other advantage of the system put through with an ordinance is that an ordinance can also be changed. So if you have that monster contract that absolutely is price sensitive and the language is problematic and it's something else we need to, and then this is a topic we need to deal with, we conduct an ordinance and we consider a modification or an amendment to that ordinance. And so I think to have a clause like this in a charter ties the hands of the county on a new topic that is just not fiscally sound. And, you know, just in terms of fiduciary duty, it's unwise. Let me also just mention briefly on the jet ski case, because that's often brought up, and there's a little detail about that people often forget. The jet ski case came out of a problem in July of 1995, at which time the director of parks took immediate action that was later found to be unlawful and prohibiting jet skis from launching from San Juan County Park. But at the same time, there was a desire to take some action and be bold, as Kevin says. And there was a desire to take action in the month of July. My advice was slow down, request information from everybody who's going to be affected by this, and hold a couple of hearings on this topic. And so they did that, and they invited the National Marine Manufacturers Association to come to Friday Harbor, and they came and they testified and they provided us with information, and that all that was taken into account before a final policy and approach was written up and adopted. And so I can say that there's a need and part of that record of inviting all of those interests and competing interests to make presentations, to testify at public hearings and before adopting a measure is really critical to the success of that measure. And, you know, it hasn't happened very often because of the circumstances. And I can say that in order to do something like that, it's absolutely essential to go slow and hear from all sides. And so, again, that could happen through the county council's process if they chose to do this. So let's keep moving.
Okay. Kyle, you're on mute. You still chairing us?
I am. Sorry, I dropped out there. One vehicle went by and dropped the connection. Okay.
Are we okay with moving on? Or
Yes.
did you need to hear what Randy said? Just looked at your name. I called you.
No,
Yeah.
I think I caught all what I needed to. That wasn't jet ski. Thank you. Okay, so next one, please.
Okay, so I'm going to bring up the other amendment. I'm going to stop sharing.
Thank you, Sharon.
I'm going to go back here and bring up this amendment here. Okay.
Oh, hey, Sharon, can you do if you go to review and get rid of those, take off the formatting function, because that's a bit scary to look at that way.
Okay, let me see if I can do that here. Let's go review.
Yeah, and then go to okay,
That's
that
final. That's final, not showing markup.
That's fine.
Is that all right? Okay.
That's fine.
All right.
Okay.
Okay. First question I wanted to, I'm glad we had the chance to meet after my my short trip. One of the people that I spent some time with on my short visit was my sister, Lisa. She's my older sister. She's worked overseas for about 4 years, and I'll wait till the plane passes over whosever house it's passing over. And I told her that I was involved in this work of the commission to on this subject of justice, equity, inclusion, and diversity. And she was quick to say, "Oh yes, that's very popular among the NGOs she works with overseas." And she's currently working with Catholic Relief Services. And she says, "We call it red eye." And I said, "Red eye? Why do you call it red eye?" And she says, not instead of with the letter R. And she says, "Because our first word is not justice, but it's respect." And I said, "Oh, that makes some sense." And so the first question here concerned why using the term justice and the meaning of the word justice. And my point there was just simply that I work in the justice field all of the time. There is criminal justice, juvenile justice, justice in every aspect of court decisions that come down all the time. It's a word that's frequently used. It's been in the books for a very long period of time. It serves as a point of court decisions, everything from the recent case involving Bill Cosby, unfortunately, the way that case ended up, and to decisions by the prosecuting attorney in connection with dismissal of charges, what we call in the interest of justice. And I see that there's a different definition that you have and meaning to the word justice. And I was just confused. I'll acknowledge I was confused that you were thinking the same way about justice that I think about it in the criminal justice context, juvenile justice context, interest of justice context. And so I said, well, I'll just identify that as a topic, and maybe there's another word that works. And so I just asked, I'm not, and I know it's probably too late in the process to change a word from the word justice to respect. But I just point out that that is a term that is used in other contexts and with other organizations. So I honor your approach. I think another word would work better, but there's no strong legal reason to change it.
Okay.
Okay, appreciate very much that input. And I also appreciate that you go to family members for your own counsel or anyone else. That's great.
Well, she's very involved in this kind of stuff. So,
Jane, did you have any further questions on terms at this point? You want to discuss that any further?
No.
Okay.
Thanks.
okay, thanks for explaining that. And
Okay.
this will be very important if that topic comes up. This piece of paper will be very important if the purpose comes up.
And we would be happy to provide any further, clarity that may be needed. And I appreciate the opportunity to, sort of at last be clear, what the context in which we are using this word, which very much is the context in which it's used in Resolution 31. And that's why I made that point. So, and I regret that we didn't make that point earlier, but it's good that we have, and we're happy to, particularly respecting everything you've shared with us in your legal reviews and the opinions you've provided and the background in terms of the separation of powers, which has all been very, very informative. I can speak for myself anyway. I found it very enlightening, how you've articulated that to help us understand the meaning and importance of the separation of powers, et cetera. So I do want to say thank you for that, and I'm just glad we could share with you where we were coming at with it. And I've also worked in the field of international development for more than 25 years, and I'm quite familiar with how these concepts are used by countries and governments and development assistance organizations all around the world. So I know Catholic Relief Services very well. I've interacted with them in the field. But yeah, so that I appreciate hearing also what your sister's experience in that in terms of the terminology. I hadn't heard of READY before. And I work a lot on these issues in my professional work. So that was, yeah, I'm interested to hear that. So thank you, Randy.
Okay, so the second question concerns the amendments that you have drafted here. And I saw that there were some emails talking about the not including the judicial branch of government as part of this commission. Yet I think the language shows it in there, and I'm just I don't see an exception for that. I was expecting to see an exception.
So if, Kyle, if you don't mind, I just want to talk through that with everybody a little bit. So Sharon, if you could scroll down a little bit, because I think correct me if I'm wrong, Randy, what you are referring to is this sentence at the bottom of the screen right now: the commission shall have representation from each branch of the county government. If that's what you're referring to, I just wanted to explain what I meant by that. And what we're thinking about here is the value that there could be in having, for example, and I'm going to use a person as an example, someone in the role of what, for example, Linnea Anderson does in the office of the Superior Court judge, and given the extent to which in her day-to-day work she interacts with these kinds of issues, and having somebody like that as a resource on the commission to be there and share, for example, at a minimum, some just basic data or statistics that could be of value in the work of the commission in understanding, if there are certain trends or, with regard to how people are experiencing, potentially discrimination or marginalization or profiling or anything like that. So it's not about, it's about having, officials from the branches that can, can provide support and information that could be useful in the work of the commission. So that's what we're sort of driving at. And just as a point of interest that I think we've already shared with you, Linnea Anderson, as you know, because you know her, I mean, she's extremely committed to these issues and these concepts, and has followed literally almost every single meeting we've had from when we first started meeting in February on the 22nd. She's attended, she's the only member of the public who's attended virtually every one of our meetings, and is quite interested in the idea that branch of the government, so to speak, in the form of that office, could have the opportunity through a commission like this that would also have residents sitting on it, could have the opportunity to share experience and learning and knowledge and even tools and skills that could be of benefit. So for example, she shared with us, how officials in that office, for example, need to get certain types of training periodically, and they have access to a lot of different resources related to, anti-racist training, to unconscious bias training. And she said, the Superior Court gets all manner of this stuff and would like to share it within, with a commission like this and with other parts of the county government. So that's the spirit with which this is coming, if that helps. Your thoughts on that are welcome.
Yeah. Well, I believe you need to accept out under separation of powers principles, the judicial branch. If the judicial branch wants to have a group involving justice, equity, and diversity issues, then it will have to create one for itself. And it should not be part of the same one created by another agency, and particularly the legislative body, or as a legislative measure through the charter review process. That is a basic fundamental separation of powers concept. And it's, I looked because into state law on this topic, and on equity and diversity, the matter was a matter of state law, and a commission has been set up under state law for state offices. And I mentioned the bill in my comments to you, or my memorandum to you about this topic. And it specifically accepts out in its definition of the agencies affected as the executive branch only, and not the judicial branch.
Okay. Okay.
I think if you contacted the judges, Judge Loring and Judge Jewett, they would agree that one branch of government shouldn't set up a commission for them to participate on. And there's potential for, I see all kinds of difficulties in terms of either what can truly be shared because of the confidential nature of cases that haven't yet been decided or appeals have not been completed. And yet there is a desire to stay on top of these things. I think the notion of having a judicial member as a guest to the commission on a periodic basis is allowable. And it's my personal belief, I let the judge decide this for herself, or either judge decide it for herself, that the duties of the judge to not participate in extra activities that may, unless they strictly involve the law as applied to their branch of government, are not proper, and they have to keep a certain amount of distance. It's lonely being a judge, and that's part of doing the job with the detached independence and discretion that they are afforded. So I think you need to make a specific exception here. My other the other language that triggers this branch is at the top on line 3. If you could move it up.
Am I there?
Yeah,
Are you
should
just in
provide
front of
advice and support to and collaborate with the county government, elected and appointed officials. Okay. You have elected and appointed officials. When you use the word elected officials, the judges are elected officials.
Okay. Okay.
And so I would use an exception similar to what's used in Article 11, or Article 11, Section 4 of the Washington Constitution, where exceptions are called out for the judges.
Okay. Okay. Can I just follow on from this, because I hear what you're saying. I did notice, by the way, Randy, when I went back and looked at the language creating the Human Rights Committee, or in the Charter of Snohomish County, where the Human Rights Commission was written into the charter, and it was established that the county council shall create an ordinance that creates it, so to speak. It was under the executive branch of government. I did notice that Human Rights Commission is something that was struck by the executive branch. So that helps me understand even further what you're talking about here. So that's helpful. I for my own thinking, I can imagine that it could be, on an appropriate basis, yes, invite someone from from, say, one of the court's offices, or from perhaps even your office, or what have you, subject to it being considered deemed appropriate. I have a question. I'm curious about one other thing, though, and that is that the state required that all counties create a law and justice council, which you serve on, along with, along with others from other, from executive and legislative, and then also judicial. So I'm curious, because there you come together, right? And you deliberate all manner of things. And I spoke with your colleague who's the chair of that body and got a bit of a sense from her, the things you do. And so how is it that, I'm curious to know how it's okay that the state, because how does that not violate a separation of powers for you guys to meet as a council at the county level?
Number one, we're directed to by the Washington legislature. Number two, the scope of our mission is much narrower than what you have proposed here. And so it doesn't involve recommendation on executive and legislative actions to advance core values of laws regarding non-discrimination. It deals very specifically about the nuts and bolts of movement of prisoners, preparation for the big trials. Where are people going to be? Where do we put jurors? What are the conflicts that we see happening? How are people going to move about and do things and develop a plan in advance of those things occurring? And only recently has it broken out with some more just kind of educational kind of things for those who are able to attend. That's what I would say about the Law and Justice Council. That if you look at the state law and the mission, it's much narrower.
Yeah, I also, you'll recall that I had a chance to speak with Mr. DiGiulio as well. Yeah, Lindsay, and then also the lawyer that
Mike, yeah.
Okay.
No, Steve.
Yeah. I hope you didn't get a bill for that. He was very helpful. Okay. I said, look,
he's a senior attorney who's been in the nuts and bolts of this stuff for a very long time.
Yeah, it was fascinating. I should send you the notes to that discussion. You'd find it probably quite interesting reading. Okay. I hear what you're saying. And then one other thing on that, because while we've got you here, I want to raise again with you something that you've heard us talk about, and that is the idea that Law and Justice Council be able to have a resident of the county sit on it, or maybe more than one, when it would be appropriate, depending on your deliberations, because what Lindsay told me was that sometimes there's matters of security that are strictly confidential. But from Lindsay's perspective, she did not see a reason why the composition of that body couldn't be expanded to include, the representation of residents, citizens.
Yeah, I heard that was going to be a recommendation, and I agree with Lindsay on that. It could be expanded to include a citizen. It includes some citizens who are outside the normal scope of these kind of things. It includes the town administrator, for example, I think. We often have somebody from the Department of Corrections who, may or may not need to know about some of these things. And we're very accustomed to inviting people to and their involvement if we have to deal with other topics. And everybody's very accommodating in making sure that happens. So I don't see an issue with respect to that kind of recommendation.
It was okay.
So
yeah, go ahead. Just one last thing, Kevin. What we were talking about, our subcommittee, and we shared this with the full CRC, that the idea that the chair of this commission, if this commission gets adopted as an amendment by the voters, that the chair of that commission could be the one or one of the representatives on that Law and Justice Council.
Yeah, excellent. So I really wanted to go back to the
you could do that. And you could include that here, or you could do it as a recommendation.
Okay, go ahead, Kevin, sorry.
Oh, I
cut you
actually,
off.
just on Randy's last point, I like the idea of including that in the amendment here, that one representative of this commission will serve on the Law and Justice Council.
Okay,
So adding that in here. Go ahead.
Where there isn't already duplicity. you
Yeah.
mean?
Yeah.
Yeah.
So back to the previous conversation though. So I've done a lot of research on this and also had many of my own conversations, and I haven't found anything. There's not a legal problem with including the language that we have that includes even the judges. And Randy, I'm posing this, I'm not stating it as such, but I'm posing it as a question too. Is there an actual legal issue there? Because yes, I understand a separation, but this commission is advising and supporting. So they're providing advice. And in our conversations with Judge Loring, we got into this, and she was, supportive of the concept. She was also very clear, as you pointed out, there's some stuff that's absolutely confidential, and this commission's not going to be going in and questioning some decisions she made. They may look at so they're not looking at metadata, but they may look at, very broadly, and this would never be the case, just knowing our judges and our community. But I could see a commission like this in another community maybe saying, hey, 90% of the convictions have been minority folks and they represent 10% of our population. That's the kind of thing that I could see coming up, not questioning an individual decision. And so the commission will be really looking high level at how they can support and advise the entire county. And so in all the conversations I've had and all the research I've done, I really understand what you're saying about a separation of powers, but that's more specific in my understanding with regard to some of the decisions, not on an advisory panel.
The judges can have their own advisory panel, and the executive can have his own advisory panel. I do not think that they overlap as you've proposed here. I do believe that there's a legal, I have stated it as a legal impediment, and I believe it's provided for as a prohibition under Article 11, Section 4. And I think you need to exclude the judges. I want to be clear about that. I do not think you should construe Linnea Anderson's participation or either one of the judges' comments or concerns up to this point as an acceptance or of this as written.
Okay. And I'm not,
yeah.
hang on, and I'm not saying that they've seen this and said, thumbs up, this is great. What I'm saying is, in the conversation, some of the same issues came up, and we had a bit different understanding. But I'm hearing what you're saying, that you actually believe there is an actual legal impediment. So there could be a legal challenge that we could lose on this. As an advisory body, my thing is, if they had teeth, if this commission had more teeth, I can see that. I just don't see it as an advisory body.
The judges are independent. They attain their independence by not receiving advice from anyone other than the people they ask for advice from. And that's the way it's worked in every county. It's up to the judge. That's how the judge retains their independence. I'm very, I don't know. It's just, I believe that's what the law would say.
I understand. Okay. Huh.
And so there is some amount of duplication. And right now the Supreme Court has a great deal of interest in these topics. Okay. It's being led by Stephen Gonzalez.
Mm-hmm.
And I think what you're seeing from the Supreme Court is a great deal of training, support, and sharing of information by the judges, with the judges on these topics, absolutely appropriate. And I would say, let the judges do their thing. Try not to include them in something here. If you do, you jeopardize what you're doing.
And
okay.
Just so I'm clear, Randy, and I think you answered this, but I've had some connection issues. you're, by extension, you believe that for anyone in the judiciary, whether they're sworn or elected or appointed, or so any clerk or person who operates in the judiciary in the county has to be invited, as opposed to could serve in a position on this commission.
I would say that, yes.
Okay.
The judge, Lene Anderson, reports to the Superior Court judge. She is part of the judge. The Superior Court clerk has a dual role. Sometimes she is the clerk for the judge. Other times she's a county clerk independent from the judges. And so that's a little more complicated. I'm sorry about that complication.
Okay.
Randy, can I ask, is there language you could share with us that would enable us to adjust that clause where we, in a manner that we can be clear that we're not talking about
The
elected?
judges?
Yeah.
I can, I think you've sent me this, I will put in an exception for that.
Okay, that would be helpful. I'm assuming the subcommittee here is okay with that?
I need to have more of a discussion and think about this.
Okay. So, okay, all right, maybe then let's discuss.
I'll send it to you and you can choose whether to use it.
That's great. I was going to add, just so you appreciate this goes before the general body tomorrow. So just to be difficult once again, the sooner this information is available, the more we can share ahead. I think we all appreciate it. Certainly appreciate you extending that.
Yeah,
that
I have it in, let me make sure I have it in Word.
Yeah, you do.
Yeah, I remember I saw it with the changes, so I'm sure I have it in Word. If not, I'll get it from you, Jane. I'll call you up, okay?
Sure, yeah, no problem.
Okay.
Let's see. Keeping going on your series of questions.
Okay, I'll just interject. It's 5:30 and change now. Everyone okay moving forward still? Just a head nod is okay. Yes, okay. This is
There's only one more question anyway, so.
Okay.
Let's see. Jane, thank you for writing up the questions. The last question.
The proposed tasks and functions, whether they
I think the way you have it is excellent.
Okay. So you're saying don't include the tasks and functions, or is that your suggestion? I don't know. We're just having a conversation because we haven't even as a subcommittee talked about this, and and I don't want to put we're just still exploring it. We'd like your thoughts on that, but because what the Climate and Environment Commission did was very clearly that. So that's why I just felt while we have you, because we've got to get this done, getting your thoughts on this so we can finalize would be helpful.
When you put things into the charter, you have to remember something, and that is that it's very difficult to change the charter. So if your tasks and functions both are specific, which is helpful, and limiting, which is makes it difficult to change. So there's an advantage to you of having the tasks and functions determined by the county council. And I think it's a safe thing to do because this group will have the opportunity to participate in front of the council and to take lead to formulate what those tasks and functions are. They will also have the ability to do it through their bylaws and their own rules of work, particularly in terms of exactly how they're going to go about doing their task. A very broad definition of the purpose is there, so that's what you have.
Right.
I think the way you've done it is appropriate.
Okay. Okay. I think that's, yeah. Is that Kyle? Yeah. Are you, Sharon, Kevin? Are we good? In terms of moving.
I think we've received some solid advice, and now I think we need to get into discussions and make
Yeah.
decisions.
Yeah. Yeah. Okay. So, Kyle, what do you suggest? Oh, we lost Kyle again. Randy, I think, oh, no, Kyle, you're back.
Another car
Okay.
drive by?
Nope.
Kyle, what do you suggest now?
I'm just checking in. Did you get your question and points
Yes. Yes.
satisfied on that question?
Yes.
Okay. I think at this point, Randy, if you have any kind of general comments to share, as we're going to deliberate some tonight, and this will be on one of the many topics for CRC's meeting tomorrow. So, any other sort of final thoughts or?
No, you've been very inclusive. Thank you. And I appreciate the chance to talk to you.
Well, we thank you for that time. This would help, I think, a lot of people, and
Yeah, this has been
really,
really.
I think it's
All right.
your time acknowledging that it's a Sunday, and
Yeah.
thank you so very much.
And
Okay. That's
Randy,
great.
Randy, before you leave, I have one absolute non sequitur, but I just want to make sure. Do you have the ranked choice voting amendment before you?
He sent it
I
back.
submitted an alternative to ranked choice voting.
Okay.
Right.
Okay.
Yeah, and I'm getting some good advice on that, so I'm going to have something to present on that.
Okay. Well, so Sharon, I'll follow up with you after this. Sorry for the rest of you. I just needed Megan and I are doing our absolute final list, and I don't have a ranked choice voting period on that final list. So Sharon, I'll follow up with you after this call.
Good. Yeah, fine.
It's not, yeah. So, and Randy, thank you for your input
Yeah.
on that.
I
just wanted to make
sent
sure.
my,
No, I
you've
saw,
received the
I saw,
materials from me, but
Right.
I've not seen anything since I sent those materials.
right. That's what I'm checking. So thank you.
All right.
And
Mhm.
thank you for your previous input on that one too.
Okay.
Yes, thank you for that.
Bye, Sharon.
Have a great evening.
Yeah. Bye,
Thanks a
Kyle.
lot.
Bye,
Okay.
Jane. Bye, Kevin.
Bye-bye. Thanks, Randy.
Bye.
Okay. Mr. Chair, where does that leave us?
Certainly helpful. I'm surprised actually by some of it. Not surprised by some of the hardening on some of the points. I feel like the last topic is, I don't know, am I freezing in the process? That is easy.
So now you're okay. Sometimes
I feel like the last piece was maybe the most eye-opening. I don't see an issue. I mean, if a particular branch wants to participate, I don't see where the PA needs to weigh in. I don't see a separation of powers issue in terms of advice, generalizing advice. I don't think that the advice of a particular group of people is going to fundamentally change a judge's principles or sway them or weigh on their mind. I don't see I see the guarding against that, and it's appropriate to bring it up, but I don't think it passes the sniff test. And so I'm also not willing to necessarily go to war over it. And I don't want anything like that to blow up the whole boat. So I don't know really how to make that. There is a loss by not having the judiciary represented in a group that talks about, fairness and anti-discrimination is, it's not the end of the world, but it's a fundamental loss, and I'm not sure how to get around that. So I would love, if you guys have time, I'd love to talk about all of these pieces. And I think there's some wins in there that keep us from having to discuss a whole bunch of new stuff. But I'll ask this: where do you guys think we need to be for tomorrow, between what we have already and what he put in, and where we need to get the group buy-in? Kevin.
I was just gonna to move us forward, maybe. There was a couple areas where I think we have consensus, where I saw some nodding. So just let me throw those out there and see if we can get those off the table. So one is, it seemed like all of us were nodding with regard to keeping the word justice in there. And he even acknowledged that he had misunderstood our interpretation. We had different opinions of what he was thinking justice in terms of specifically the law and justice program that he works within with as a prosecuting attorney.
Which was said to him in public session as a means to steer him, and he couldn't hear. So it just took weeks to learn.
No, and
Yep.
he'd received, yeah, anyway, I finally put it for him on paper in black and white, and clearly that's what what he needed, because now he can't deny what our intentions are. And unfortunately, he has misinformed repeatedly our fellow commissioners about this for months now, which is really unfortunate. But anyway, be that as it may.
And also, you know, I will speak for myself, but I several times have been so deep into a subject that I can't, can't see the forest for the trees kind of thing. And so
yeah,
I don't see it as a negative. I don't see it as a negative for our prosecutor. I see it as, he's intensely focused on his area.
True.
He came in a different perspective. So
Sorry,
so
true. Yeah, I shouldn't be that critical. Okay, I take that back.
Justice in there for sure. The second piece was Kyle. I think that the suggestion you had of separating, and this came from your conversation with John Kane, who Randy said, I'm not the expert on this. I've got a guy in my office who is, please talk to him. So you went and talked to him, and the idea was separate it, that we can go there with regard to professional services. We can't go there with regard to goods, and we can't go there with regard to federal contracts or grants. So I think having language that separates those and says, we're going to be as hard as we can and as bold as we can with regard to the areas where we have the jurisdiction to do so, which is, if we're going out for bid on a contract that's specifically for a county product or project, we have that discretion. If we're going to get, you raise the issue of federal healthcare dollars, they're going to, go. I will say that the conversation I had with counsel of a large tech company was really, they were very clear with me. They were like, you can't even mention that we're talking. So I can share what I'd heard, but I can't say who it was. So, but they were very clear. They actually welcomed it. They said, we think it's great if you guys go forward. But they also did acknowledge that the prosecutor's argument is valid, which is there are some companies, and they brought up and they said, I don't mean to jab the auto industry. And they said, but I'd be surprised. And one of his friends is actually general counsel, one of the large automotive folks. And he was like, I'd be surprised if they've gone as far as we have, or as other folks in the tech industry have. So anyway, the point is, I think the idea, Kyle, your idea after speaking with Prosecutor John Kane makes sense. Let's separate them. So if we can agree on those, there's two things out of the way. One, we're keeping justice in the title. Two, we will allow exemptions for federal contracts and grants and for goods, but not services.
Can I suggest something here? I for my purposes, it would be really helpful if we just went through the two separate amendments and sort of referred to the questions we asked and what we heard back from him on, because that's for me, that would just help my brain sort of work through them. Because I just kind of want to refer back to what we were asking him and think about. Yeah, so I know we're kind of doing that, but we're not doing it in any order. And there's a few things for each amendment.
Do you need it visually?
No,
Well,
I just want to. I just kind of wanted to go.
Do you need it to be posted?
Not necessarily. I have it right in front of me, but I mean, if you need it, if you guys need it, I just thought it would be just a little bit more organized if we could go through the points that we discussed with him. And
What
so we can
other-
finalize these.
Okay, I was just trying to suggest that there's 3 areas that I think we need to finalize. 3.
Do you want me to? I'm sorry, Kevin. Go ahead. And then I'll ask my question.
I was just going to say, and it feels to me that 2 of them are resolved. One is, are we keeping justice? Everybody nodded, so I think we can vote on that if we want, but I think we say yes. The other is we use Kyle's suggested language or process from his conversation with John Kane on the other. And the third piece then just goes back to the last conversation we were just having with Randy.
Okay, so yeah, I hear what you're saying. The reason I'm if we go back to the non-discrimination amendment for a moment, there was a decision, not a decision, there was a suggestion that we don't include non-discrimination towards for people who've been criminally convicted. So we have to make a decision on that, and we haven't yet. We got advice from him, but we have to make a decision on whether we do not include that language in the non-discrimination clause 1, or whether we feel strongly we should. So I think
We have
let's
2 options there, I think. There's a plane going over. One is to decide now and unify and put that forward with the group, or to put that component of that amendment to a vote of the group tomorrow, and see if the group has consensus or heartburn over that one piece.
okay.
It's not my favorite, but we do need to
Can I
make
share with
progress
you-
and close it.
Can I share with you my strong preference here now, having chaired at least 3 of these very difficult full CRC meetings on our work? I do not want to go into the meeting tomorrow not being in a solid position as a subcommittee on each of these issues. I just do not. We can't do that again. I don't think there is an ounce of appetite for this among the full CRC. We have to go in bold with our recommendations to the full CRC. Obviously, we have some discussion about it prior to a vote being taken, and we can have that discussion, but I don't want to be putting it out there as like, we don't have a position.
Well, that's okay. I get that, and I can be on board with that, but I think that leaves 2 scenarios. One, we have to be okay leaving people behind who can't wrap around how bold the commission is, or how bold the committee is, or we have to bail on some things that we feel really strongly about in order to increase the appetite, which I don't really want to. I mean, I will do that, but both are sacrifices. And so now is the 11th hour where we either try and get more consensus, or, we potentially don't. We won't really know this until there's something of a vote count. If the tradition and the introduction to this as a reminder and to bring everybody along tomorrow works well, we'll be no worse off, I would think, in the numbers that we have. And so that was what, 6-12, something like that, if everyone shows up, or 5-13. That's one of the weaker moves forward, and yet it's still a move forward. I'm okay with that. I think that's something that happen if we which is how we make it bold. But
Okay,
if we
can we talk about the criminal conviction inclusion then or not, and whether we have whether we are all on the same page or whether we have different views on that point?
I'm sorry, one time.
Kyle, maybe turn off your video. Kyle, are you able to turn off your video? I think that would help with your bandwidth.
Let's send in a message.
Would you like me to send you my notes that I took from this meeting?
Not yet.
No, I don't need them. I'll try it with video, and then we'll. Jane, would you take over can I make you host, and then I can call in? I'd much rather be able to hear you consistently than. Let's try it this way for a second.
Okay, let's try it this way, and then yes, absolutely if necessary. Okay, so I feel like on the non-discrimination clause 1, we're almost done. But we do have this, for me, there's still this outstanding issue on it applying to convicted criminals. Where do we all land on that?
on the level that Randy brought up, I mean, I don't like this. I appreciate what's there. I think it's well thought out, but there isn't, he made the point that there isn't necessarily, I haven't heard that there's a problem. That maybe changes it. I don't know. That's a challenging thing. If we keep it in there, I think that's one of the places where, because people have been so public about wanting it to go away, all the lawyers, as you said the other day, plus James Wolfe, I think it was, it's a stickier point. So,
I mean, he made the point that the more you add in there, the more you risk opposition to the amendment.
Look, but we're gonna have.
Okay, go ahead.
If we operate with that mentality, we can throw our arms in the air and give up.
Okay.
So I'm sorry to be dramatic there, but the reality is, if we're concerned, anyway, I made my point. I'm really torn on this point. Redemption is important. And Jane, I know that when this came up, you were one of the stronger supporters too. So I imagine you feel the same way. I heard him say that he and the sheriff do this. And he also mentioned that, and I wish I clarified this. I wrote it in my note and I forgot to circle back. He mentioned that in certain areas of employment, he has to do a check. I don't think he has to do a check on every area of employment.
He did say he does that.
He said he does. He said he was required to, and he mentioned a couple of different areas. And so that's an important difference for me. So if he's required to do it, then I get it. And so, like, for instance, you're not going to hire some, somebody convicted of a violent felony in certain areas. But so, I mean, maybe we could have language that says where you're required. I'm just, I guess I need more advice on this. I am disinclined to just throw it out. I mean, I also, the ban the box bill passed the Washington State Legislature 3 years ago. I don't know how anybody's checking. That bill said you're not allowed to ask. Now, maybe later, I think we actually had exceptions for later on. So before hiring, you can get into some of that. And then I think there were exceptions in there as well for federal and state requirements. I'm frustrated that we don't have the time to do more research on this at this point. But I also, what I heard him saying is he does this. And so he has a concern, and there's certain areas where he's required to do it. What's unclear is if he's required to do it just because you work in the PA's office. I don't think that's the case.
Well, what's clear to me is that he's stuck on hiring and missed the point, I think, about the ways in which this really that impacts people one at a time, but the way that folks are impacted in community is less in hiring and more in how they're treated, or how they can interact with the county, or do business, or not be profiled by the sheriff's office, or any number of things. But I mean, I've learned from Kevin the point counterpoint approach. It isn't, I mean, in this 13th hour, it is not by itself. That one piece was a late addition, and I can live without it this time.
It's not in there currently, just to be clear. The language is not in there. It wasn't voted on by the full commission to include the language.
I thought
So
we
it's
had,
not-
I thought Doug
No.
put a motion on the floor. No?
It's not, it was not voted on favorably. It did not get in there. So it's not in there now.
Okay. Then let's go with where we are. And not include it.
Okay. Where does that leave us? So were there other, let's see.
Well, his final point.
He
which
brought up,
the final discussion we have with him, which for me is the biggest deal.
Okay, so I need to ask if we could, so sorry, just 1 minute, before we move off of non-discrimination, I'm sorry, but on the issue of the contracting, I mean, we, you know, I am a bit concerned about including it in there, even on an exceptional basis. And so I'm quite of mixed views about that, to be honest. And
Sorry, Jane, I'm not clear on what you're.
the contract provision, number 2, the idea that would include Kyle's amended version. I'm not 100% sold on that idea. I did listen to what Randy had to say, and I saw a lot of it did make some sense to me. And what particularly when he talked about it being dealt with as an ordinance instead of being dealt with in the charter. And I'd be interested in Sharon's thoughts on this as well. But it did raise questions in my mind as to the validity of including it in the charter. And I'd like to hear Sharon's thoughts on it.
You know, what Randy said made sense to me, but I'm just not that knowledgeable. So you know, it sounded reasonable to me, you know, to let this be to recommend as an ordinance. But I don't know if I really am that confident in, you know, what I'm supporting at this point.
Yeah, I hear you. So keep in mind, if we did go ahead with Kyle's language, we haven't run it past Randy, which we're going to have to do, and he's going to have to comment on it again.
No.
And
No, we don't. You guys, we don't have to run everything past Randy. There's no obligation whatsoever. It's just a part of the process we've been doing. So we can finalize this, vote on it, and say we're good. And then if there's issues that come back, you know, as he's working on it, that'll be editorial. What we're saying is we want to do it. We get to make the decision on what we want to do.
okay,
Period.
I hear what you're saying. I hear what you're saying. The way Kyle has worded this clause, though, it includes both cooperative purchasing, which I understand to mean goods, as well as professional services. So if you are now saying that it would only apply to contracts related to professional services, then what Kyle has drafted needs to be changed to reflect that.
I didn't read it that way, but Kyle, how do you?
Yeah, I didn't either. I'm going to pull it up and so
Well, then, and it would be helpful then, Kyle, for you to explain it to us.
the county shall seek adherence to the grounds listed in clause 1 to the extent possible in its selection of contracts with any person, firm, organization, corporation, or other non-governmental entity for cooperative purchasing and the delivery of professional services. Existing policies and guidance for non-discrimination held by public entities soliciting contracts and grant.
Are you there?
Oh, Kyle, we lost
Covers all 3 things.
you. Kyle, we lost you there for a second.
It is after conversation. It's sought in saying shall seek as opposed to requires or shall not enter.
So,
Kyle, we
yeah.
lost you there. Do you have a phone? Could you call into one of the phone numbers?
Yeah.
You want to do that, and we can just pause, and then Jane, are you host now?
Yeah.
No, I'll make her host right now. Am I back?
Oh, I thought it was. Okay. Yeah, you're back.
I'm sorry here. Sorry, guys.
No worries.
It'll take me a second.
Okay. So,
Okay,
Kevin, what
Jane,
do
your
you?
host.
Thank you.
That
I
work?
got it. Yeah. Kevin, what do you understand cooperative purchasing to mean? I mean, are we talking? Is that the purchasing of goods?
That's my understanding.
Okay, so the way it's currently worded,
Well,
that's not.
Hang on. I need to look at it, and I want to hear Kyle explain it, because when I first read it, I understood it as a separation, and that's what we need to do. We just need language that says federal contracts and such, and then purchase of goods, but not services.
Okay, so I'm going to share a screen on this text. Okay.
Okay, go ahead.
So we can all be looking at it, and
And keep an eye out for his phone coming in.
Yeah. I don't know if this is it. I don't think it is. God damn it.
Hey.
Oh, sorry. Excuse my language. Oh, sorry. I'm sorry. I'm just. Oh boy, just a moment here. I'm just trying to find the right document. Okay, let me put that up. See if I can grab it that way. Just a moment. Do. Sharon, do you have it? Oh, I've got it, Sharon. I found it.
Okay.
Says I'm sharing screen. You don't see it, do you?
Nope.
Not yet.
I'm not seeing Kyle coming in yet either.
Do I have it? I'm not sure if I have it.
Yeah, he sent it to all of us.
Okay. If you want to send it to me so I can just grab it quickly and I can
Okay,
share the screen.
I think I might be able to get it here.
And guys, I've got to jump soon. I've got to get on a call with Megan and finish everything. So
When should we talk about RCV?
I don't know. I don't. That's second year anyway, though, right? Second.
That is second year, yes.
Okay, so I'm not as freaked out about that. So we don't need to do that tonight.
Okay. And I am working on that. I've been in touch with David O'Brien, who wrote the original language for the proposed
Okay, can you see-
initiative.
can you-
So I've got good advice there, and I'm working on it.
Okay, so can you see the language on my screen now?
Yeah.
Okay, and for some reason my computer is doing something very strange. All right, Word has insufficient memory. Do you want to save?
Just say no, and you'll still be able to
okay.
see it. Yeah.
There you go. Yeah, right. I don't see Kyle yet. Just so you guys know. Okay, just a sec. I'll go back to. Yeah, I'm not seeing him. Yeah, it'll notify me if he calls in, right?
Yeah, it'll say somebody's
Okay.
waiting.
So before we get into this though, so Kevin, because we've got to be very clear on next steps here in terms of what we're trying to accomplish by the meeting tomorrow, and I'm very concerned that we don't all have agreement on certain things. So, what are your thoughts on how because I also have a meeting with my colleague in Indonesia at 7 p.m. and I kind of need to eat something before I meet with her and I have to prepare for the meeting. So I also need to get off this call quite desperately. So what are we trying to accomplish today with this? Are we trying to get these two amendments to?
I think we go with this language. I think this does it. And then because this came from his conversation with John McCain, this was from the prosecutor's office at the prosecutor's advice. He said, John McCain's my guy, talk to him. He did. And then he spoke to the county manager and this language came from that. So I think this addresses that. And the folks who are smarter than me on these issues, John McCain and Mike Thomas, seem to have, I don't know if they saw this language or if this came out of those conversations, but Kyle wrote this up based on those conversations. So I think we go with this for that section. I think we we keep justice in, we remove the reference to criminal past or prosecution. And we do this one for this section. And then the last piece with regard to the commission, I think that because it's an advisory body, as Kyle said, I think we're okay. And even Bill Apple and others were saying, this is the perfect combination of pushing right up to the edge, but not going over as far as what's appropriate.
Okay. All right. Can I just, all right, I hear what you're saying. Just regarding this one though, if you read this sentence, and by the way, this is what Kyle drafted out of his conversation with these men. they didn't see this language, didn't sign off on it. He drafted this out of their discussion. He was hoping to hear from John Reed on it, but he hadn't. The way I read this, however, the cooperative purchasing and the delivery of professional services suggests that it includes the purchase of goods. I don't see any separation of that from professional services in the way I read it. Where's the exception for purchasing of goods? Okay, he's entered, okay. Kyle, you there? Hello, you're back.
His audio is not connected yet.
Connecting to audio. Okay.
Kyle, can you hear us?
I can hear
All
you.
right. Kyle, you want to tell us about this? The question from Jane was that the language that you based from your conversations with Mike Thomas and John McCain, that it's not clear that there's a separation between cooperative purchasing and delivery of professional services.
Okay, I'm going to read it here. To the extent possible in its selection of contracts with any person from. That's true. This does not make that distinction, and it should. So it needs more work.
So can you work on that, Kyle? And
Happily.
okay.
In this way, before tomorrow, I can get John Kane's time in the morning while he's in the office,
Okay.
and
Well-
make sure that works with him as well.
Okay, but I'm also at the point now where it's fish or cut bait. So I think we're moving forward with this because it sounded like Randy had a bit of a difference of opinion from John. And so, actually, Randy didn't comment on the separation as much. And so
He hasn't seen this.
Yeah, I know. I'm not
Yeah.
saying that, but we asked him, what do you think about separating it? And he answered some other parts, but didn't get specifically into that. But my thing is, I think we make a decision that we're separating cooperative purchasing with goods from professional services,
Agreed.
and that we're this does not apply to held listing contracts and grants. This
Public
doesn't-
entities.
from public entities. Okay, yeah. Okay, that's it. So that one's done. And then the last one, Kyle,
Okay.
is that Jane? Is that good?
Yeah. So just a process point, Kyle, what I can do is I'll send this back to you, okay? And I'll indicate, unless you just want to send me the language that you change. If you could just send me the language and I'll hold the pen on the final. Kyle,
I'll
are
do
you
that.
there? Okay, just send me the language.
I'm hearing you. If you could
Okay, and when can,
do it,
what is
I'll just send you the
what-
language for.
Okay, when can we have a final language for this? Kyle? We can't hear
I'm
you.
here.
Are you there?
I'm okay. I'm here.
When will we have final language from you?
What's the latest? I mean, you want to have this ready for the meeting tomorrow, of course,
Yeah,
but
it needs to
what's
be
the
shared.
latest?
It needs to be shared with people. I was hoping we'd finish it tonight and be able to send it out to everybody and say this is for consideration tomorrow.
Do it. It just won't. Nobody will. Okay, nobody will see it. That's the.
Well,
But
you
is it your
send
view?
it- you could send it to us and say, and just say, you could text us or whatever and say, hey, check your email. You got 1 hour. And then if not, then we don't comment, then send it. Or we just say, go with it. Trusting that, you're going to get
It's
it right.
important enough. I'll send it to you. I'm happy
And
to
is it
send
your
it to
view?
you.
Okay, is it your view that John would have an issue with this from your discussion or not?
I'm not sure. I happier than he was with. He wasn't unhappy, but I think it was that came up in our conversation.
Okay. All right.
I don't know if you can hear me anymore.
Yes,
Yeah.
But I think it would be a couple of words max that he would want to maybe move or change. But the fundamental concept of three pieces: goods, professional services differentiated from goods, differentiated from government sources.
Okay. All right, we're gonna,
Now, while I've got good audio, though, I want to ask you guys. I mean, the county shall seek adherence. That's a change from the county shall. Do you support that? Because that's very
Yes.
different.
I don't.
oh. Okay,
That's a should now. And now it's a should.
It's true,
It's not a shall. So
That's
there
right.
means no teeth.
but it doesn't have to be.
Why not?
I'm just saying it doesn't have to be a should. It can be a shall.
Oh.
But if we all agree that will pass, the other changes are sufficient to pass the full body. And at this point, if it's a majority and it's 9-8 to 1 abstention, I'm not sure I care.
Yeah, and
for
I think,
tomorrow.
yeah, I would say it should just say the county shall adhere to the grounds listed in clause 1.
to the extent possible.
No.
Okay.
All
I
right,
mean, if that's the case, then I wouldn't change. If you're having that as an opening line, I don't see why there's any discussion about changing any of it.
okay, so the county shall.
I think your
and
point
then-
is worthwhile.
Okay, Sharon, I'm on board with this. If Kyle can just make the adjustments and we go with shall adhere and take out to the extent possible. Are you okay with that, Sharon?
Yes.
Okay. Kyle, go ahead and send us the revised text as soon as you can. Okay, can you hear me? No, he's gone. Shoot. Okay, we can text him that and let him know. Okay, so Kevin, now we're just looking at the last thing is the regarding the other amendment. What we're talking about is and what I heard from Kyle is that we keep that the judicial, executive, and legislative in there. Is that
That's what
that
Kyle was
correct?
saying as before we lost him, and I actually really appreciate that as well, because it's an advisory body. And I understand what Randy was
Yeah.
saying.
And
I
it's-
just I don't know. But as an advisory body, I don't see the issue. If this were like the C&E commission that's being created has more teeth, and so if they were doing something on justice, if we had that sort of language to give this more teeth instead of being an advisory commission, I can see then you might want to separate just the judges, not the judicial branch, not the prosecutor or the sheriff, but just the judges. But as an advisory body, I don't see an issue there. I feel like there's a bit of a breakdown in our communications on that one as well, similar to the way we had differences of opinion on what
Construing.
this meant.
Okay. Is it worth confirming with Judge Loring that she'd be all right with someone from her office, sitting on this body? I don't, it's not like we have time, but
I think we have to put the language out there.
all right. Okay, Kyle, can you hear us?
I can.
Okay, we've asked if you could please, okay, you've just sent a text and I don't have my phone to read your text. You're gonna
Okay,
go ahead
I
and
just-
make the changes, Kyle?
I just said I will make the changes as we've discussed and ferret out purchasing from professional services, take away seek to and make it just shall adhere to, take away extent possible, and send it to you guys within the hour.
Thank you. Excellent. Sounds good.
And then
Okay, so
Sharon, which one of you is doing the master that you're sending to the full CRC?
I'm
not.
Master.
Jane, you are, right?
Master. Yeah, I got it.
Master blaster runs
Okay.
Carter Town.
So
Nothing.
what's that?
I got that.
Okay.
Great reference.
Okay, so I didn't. Okay, so last thing then, we're just going to conclude, I think, on the fact that we won't make exceptions for the judges. Well, unless, so just let me revisit one thing, and that is, he said you could make exception for where it says elected and appointed officials. You could make an exception for the judges there when we're talking about elected officials. But if we don't want to do that, I just want to confirm where we stand on that.
Here's another late question. Are we talking about the officials themselves or their office? Because there is a big distinction. So do I foresee that the sheriff herself or himself is going to sit on this commission long term?
No, you can't do that. I think that's prohibitive.
Yeah.
I think you say somebody representing them.
So
And
what he wanted to do.
Oh, go ahead.
What he wanted to do was have us adjust the shall provide advice and support to, and then have an exception there when we mention elected officials, have an exception there for the judges. That's what he wanted us to do for that. And then I think he didn't say this, but I'm suspecting he wanted us to not obligate each branch of county government to have representation, which is the third to last sentence.
I only heard him say he doesn't believe in obligating the judiciary.
Right.
Which is different than, and that's why I'm asking the question. I really don't foresee any elected themselves sitting on there, but I think you need to there needs to be that distinction between, you could take elected out completely, unless you mean the office members from, and I'm not looking at it, I'm sorry.
Okay.
But
let me ask another question.
Let me see if I have it.
Kyle, let me ask another question. I actually thought, you guys, that maybe we just say advice and support to and collaborate with the county government. And we don't make explicit reference to elected and appointed officials or county employees. No?
No.
Okay, all right.
So don't get them. They will interpret that as, okay, you're going to the county manager and that's it.
Okay, so what's your take on the inclusion of elected officials then, Kevin? We just keep it there?
Yeah, I think the language is great.
Okay.
I don't see an issue. The only issue, so my only thing is, as far as the commission giving advice, I think they give it to all of them and it's welcome. And then my only thing is on the membership. Like, do you really need to have somebody from the judge's office sit on the commission?
Okay.
And so I don't know if you need that. And frankly, I think it'd be very welcome, but I don't know if it's needed. And so you could say, and frankly, like, do I really want one person? I mean, we're going to stack the deck of this commission with all representatives of every elected official. That's less and less a citizens commission.
Right. Okay. Excellent point.
So and I'm sorry I didn't notice this earlier, but I had not caught that language. I would have probably said, we don't want any of these people on the commission. Like, I want them to advise every single elected and appointed official in the county and the county as a whole, and come up with ways to support them and helping them become more fair and equitable and just.
I disagree. I want as many people. I mean, I don't want citizen representation not there. I'm not saying that, I do, and very much so. But what better way than to have that's like the accuser having to stare down the accused. It's not. I think it's exactly where people need to hear the message first person.
I agree.
How many people?
If there's 11,
Sorry?
if the max of 11, is that what you asked?
Yeah. So if there's 11 people and you've got one from each judge, one from Randy, one from the sheriff, one from the county council.
No. Hold on, Kevin. You're misunderstanding what the statement says. It says the commission shall have representation from each branch of the county government. And then in parentheses, it says executive, legislative, and judicial. So that would be 3. And
Doesn't
from
say-
my perspective,
Yeah, doesn't say anything.
Sorry, sorry.
and from my perspective, this is about ownership. You get those people at the table.
Okay, so I'll shut up. Yep,
Not departments, just branches.
yep. I totally misunderstood. Sorry.
Okay, so can we
He's back.
retain that?
He's back.
He's back.
It's
Yeah.
critical.
Okay,
I
we're
think that's
retaining that.
critical.
Okay, then the last thing from my perspective is I wanted to confirm with you, I will add a sentence that makes quite explicit that the chair of this commission shall sit on the Law and Justice Council. Okay?
Yeah,
We
I like that.
Okay, all right. And then, sorry, one last question is I have here as the very last sentence, the county council shall appoint the membership of the commission and establish the tasks and functions of the commission by ordinance. Randy thought that seemed appropriate because the commission would be involved in that.
What, say that again?
My understanding of what he said was he thought that that was an appropriate way to handle it.
Yeah, what's the language again? Sorry.
The county council shall appoint the membership of the commission and establish the tasks and functions of the commission by ordinance.
No.
Okay.
Is this going to be an independent commission or not? If
Only a good council. Only the right county council.
the county council shall appoint, the commission establishes its own agenda. And I think
Yeah.
some of it has to be like we did with the chart, with the C&E, we
C&E.
said what their job was going to be. I think in the charter, we say broadly, here's what their role is in the charter.
Except
You
We just don't have time. We don't have time for that by tomorrow. I mean, that's not.
I've
it.
already drafted the language months ago.
Yeah, that's what I thought. I thought the language
Oh.
you had was good.
It was a bit more detailed than it need be. I think it needs to be pared down a little bit, frankly.
I would trust you to pare it down. But I am not in favor of the commission's role and duties being defined by a county council.
Nor am I.
Okay, so
And I would
um,
I would
And I
ask.
just want to clarify though, that, to Kyle, to your point, I think our current county council could probably do just a great job of that. And I would trust them to do that. However, I don't know who we're going to get elected in the future. And some of the people we've elected recently in the past, I would not trust to do that.
okay, so
Yeah.
could I have a sentence that says something to the effect that upon the first meeting of the commission or something like that, the specific tasks and function of the commission will be agreed upon or something like that?
No, I think you put it in the charter. A
No,
broad-
oh,
No,
with-
I'm not saying, I'm saying we put in the charter right now what their mission is.
but are you talking about like maybe 2 sentences at the
Yes.
most? Okay.
I wish I had the C&E. C&E was just sent out to everybody. If you look at that.
Yeah, I've got it. I've been reading it all weekend and I just find it's way more detailed than I'm comfortable putting in here. I don't want to go that way. It's 2 pages long of detail or 1.5. And I just don't want to do that here. And I don't frankly have the time to draft this, that I don't have enough time to put into this.
You had previous language.
I'm not feeling like it needs that degree of prescription at this point, Jane. I mean, your language from before, I think, is a great start, and really only the framework that's needed. What the mission is relevant for us to work on. What the tasking and the job listing or the work product or the work listing of the commission can be done internally.
Yes, and you know what? So Jane, to your previous point, maybe we do that where you say, not in the first meeting, but you say the commission's full agenda will be developed by the commissioners. But we put some parameters on that. You do like just 2 lines saying, here's the high level mission of the commission, the duties of the commission. The duties of the commission are, and frankly, I'm trying to scroll the screen. This is Kyle's language. Part of it's already in there. It says the commission shall in the very beginning. It says why
Yeah.
it exists. I think that gets at it.
Yes, I know. That's why I wrote the language that way. So that's why I don't know that we need to add a lot more detail here.
No,
I don't
agree.
think we do. All I was saying is I'm not in favor of what you had suggested, which was this idea that Randy brought up of having the council do it.
Okay, so is there a need then if it says the county council shall appoint the membership of the commission, period? Is there a need for an additional sentence?
No.
So we just leave it as is. I think that's fine.
I would agree with that.
Okay.
I would like, not to just scratch at the dirt here. I think it should be the chair or his, her, or their designee for a seat on the Law and Justice Council, because
Okay.
only because, I mean, I can't see a bad scenario, but what I don't want is that nobody wants to be the chair because of some perceived burden, time burden.
I agree. That's a good suggestion. That's a very good suggestion. Do you guys agree with that, Kevin,
Mhm.
Sharon? Yeah, okay. I'll add that. So that'll be the last two sentences, all right? No, one sentence. The chair or their designee shall sit on the Law and Justice Council of the county. Okay?
It's better. I think
So-
it's better.
I will finalize these tonight and get them off to, should I send them to you first or should I send them to the full CRC?
I'm okay with what we've discussed, and I trust your edits to make that happen. So
Let me get my thing to you, Jane, and then I'm happy if it goes, around to the whole commission. And Sharon has
Okay.
her hand up.
So, oh, Sharon, yep.
Go ahead. I'll wait. Go ahead, Jane.
Well, no, you go for it. Go for it.
Okay, so just before we get off the meeting, I just want to see if we want to say anything about the people that abstained or voted against these amendments previously, and what we want to do to address that.
I think, if I may, I think some of the abstentions and opposition was somewhat confusion and somewhat going back and forth on things that they thought were commitments. So it wasn't opposed to the general idea. It was that it wasn't ready, which is why I'm really glad we've taken an extra week to do what we've done.
Mm-hmm. Good.
Agreed.
Yeah.
So should we still be reaching out to them between now and tomorrow's meeting?
Definitely. Never have a meeting you don't know the outcome of.
Right. So, and on that basis, Kevin, would you like to send us an email and let us know in response to the one I sent to you all yesterday as to who might do what in that regard?
I think, I think if there's a couple key conversations that should happen, you guys should have them ASAP.
Well, were you prepared to have a few of those yourself then?
I already have, actually, yeah. I've
So
called a couple people just to say kind of, what do you think?
Can we stop the recording?
Yeah, and
We need to end the meeting, and then
Okay.
yeah, and also we have to be mindful of the number of people we can talk to, right?
okay, so that's why I'm being a little coy on it, and I'm not calling people and then calling other people. I've been very careful not to have a
Yes.
team meeting. What I'm doing is
Exactly.
saying, hey, you were opposed to this. Can you please explain to me why? I think that's valuable.
Oh, that's a good way to handle it.
That's what we're really
Okay.
after. I mean, I'd rather know what the motivations are before I
Yeah.
spew a bunch of my own thoughts.
Yeah,
As chair, I don't want to have a meeting tomorrow where everybody has to share everything again, even though they will.
yeah,
So my hope is that I can alleviate some of that by having some conversations in advance.
okay. Those conversations then with the one or two folks that whoever is gonna, I don't know. Yeah. Anyway, let's leave this.
I move we adjourn this work session, special meeting.
Great, because I need to go.
Seconded. All in favor, Mr. Chair, I want to call it.
All in favor? Only two of us?
Okay.
I'm in favor.
All
Get
right.
out.
No, I'm in
Okay.
favor. I have my hand up.
I see you. I didn't hear Jane. Okay. 3 to
Okay,
1, if not unanimous. Okay, we're adjourned. Stop the recording,
Sorry,
Madam
Carl.
Host.
Yeah, just one second.